What I, yeah, I'm at full charge, but we'll see how.
Sure.
But I'll tell you, but they last. Lasted 8 years, so. I grew up that way. Okay. I don't hear people admit that very often. Okay.
It can
That's funny.
be bad.
That is funny.
Ask Brian, he'll tell you all
Uh-oh.
about it.
Uh-oh. Set up with all my stuff.
I did have.
Why? Does he have a lien? Is that the problem? Because they don't have any code cases right now.
And you know how to use it? Well, I didn't do
Oh,
it.
okay. A while ago.
No, I could do it.
It'd be easier if you did, I'll tell you, I have no idea.
Yeah, I don't remember it at all. And so we're supposed to shut them down? Well, they're already shut.
So we'll wait and see.
Yeah.
You're supposed to make sure they never, ever, ever do anything there again.
I guess we have to do these logistics and.
That's a misconception.
I'm sure we're probably on already.
No, I don't want the update installed. Thank you for finding
Sure.
that. Installed.
There's a misconception that can actually try to live by the little chain across the road.
I want to be the one. Let's have Frankie out there. He'd enjoy that. Chuck was very complimentary of Frankie yesterday.
Good.
That's a
Sure,
really
I
good
can
job.
see over the,
That's good.
I like that.
I said, yeah, we coach
Say
him
that's
pretty
a
good.
first.
I said, we coach him pretty good. We work hard.
I need a
Heard lot of
booster
things, but
seat.
I've never heard that.
That's what you get for sitting at the kids' table
I'm
over there.
vertically challenged. I can't see over the.
Then look,
Do we
chair.
need two?
Look at that
We
chair.
don't need two, do we?
To do what?
We don't need two of those, do we?
No.
We shouldn't. Well, it depends on
We'll-
if
we'll
there's,
just leave
I
it.
don't know, we don't know yet, but
You know,
probably
if
not.
you switch chairs, that one's 1,000 feet higher than that one.
Well, I can make it go higher, but then my feet hang. I'm vertically
The
challenged.
drama, my gosh. I can move that podium over if you
No,
want.
I'm good. I'm good.
Okay.
I'm perfect.
We can take that up.
I'm perfect.
Later.
I'm perfect.
You're not perfect, but. But thank you for doing the minor mod. I do appreciate that.
Oh, yeah. It seemed pretty straightforward.
Yeah, it is. It wasn't at first.
I think I'm ready to go. Are you guys ready? Okay. Good morning. The time is 9:01. I'm Christian Waugh. I'm serving as the special master for this hearing, and I call this Citrus County Special Master Hearing for Friday, June 5th, 2026 to order. For these kinds of hearings, we do follow the agenda. The agenda has been publicly posted, but we'll go item by item. The first item is A, call to order. Guess what? We just had that. Item B is the invocation. So I would ask if you would please bow your heads, and I will give a brief invocation. Dear Lord, please give us the grace to be understanding, patient, and tolerant. With these attributes, we can conduct our work in a manner which is pleasing to Thee, our county, and its residents. In the Lord's name, Amen. All right, now I'd like to ask you to join me as you are able for the pledge to the flag. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you. Okay, so the next item on the agenda is the appeal process and meeting procedures. So the primary thing I want to do at this point is go over how this hearing is going to be run, the appeals procedures and the statute. I don't know if staff has anything that it wants to say on this item or it just wants to leave it to me. Okay, I take that as they want me to talk. So generally for these hearings, my understanding is we'll follow the quasi-judicial proceedings section of the Citrus County Code. I'm referring to sections 2-51 through 2-59. And as an example, general procedures is 2-54. Talks about each party having a right to call and examine witnesses, introduce exhibits, cross-examine opposing witnesses on any relevant matter, and to rebut evidence. Any expert witnesses testifying on behalf of the applicant or a party in opposition would be subject to qualification by me. Staff will have the responsibility of presenting the case on behalf of the county if it wishes. And it talks about parties in opposition, but I don't have any documents about parties in opposition. And if any had wanted to be in opposition, they would have had to file 14 days before the hearing. That's my understanding.
That's correct. We have no intervener applications.
Okay, so there's no applications. We don't need to worry about the parties in opposition sections. Then I'll go down to 2-54 subsection E, which talks about time limits. The applicant, who is the applicant? Is the applicant present? All right, thank you. So the applicant will have up to 30 minutes. Staff will have up to 30 minutes. Don't need to worry about parties in opposition. And then members of the public will have up to 3 minutes. Now, I'm going to keep track of that 3 minutes informally unless people really go beyond the 3 minutes. I want to keep it roughly equal. If people are kind of violating that, I'll tell them to kind of wrap it up, or I'll just start keeping track on the clock. I will give the applicant an opportunity to address the public comment up to 15 minutes and then have final argument. No speaker may give his or her time to any other speaker at the discretion of me. The allowable time for any testimony may be extended. If additional time is given to the applicant, an equal amount of additional time would be given to any parties in opposition. We don't need to worry about that. Subsection F talks about documentation and exhibits. It says no later than 14 business days prior to the scheduled hearing, the applicant and any proponent or opponent on the matter may submit any written arguments, evidence, explanations, studies, reports, etc., to be in support or in opposition. And then no written materials will be accepted by the board or special master at the hearing unless, in my discretion, acceptance is necessary to decide the issue, meaning that if anyone here today has documents that haven't already been provided to me, it'll be subject kind of to a high bar for admission. And then we go to section 2-55, the order of the proceeding. And by the way, I recognize some of you may already know this. This is for the benefit of the public and all of our viewers on YouTube. Section 2-55, order of the proceeding. Subsection A, upon the calling of the matter by the special master, the applicant, staff, and all witnesses requesting to provide testimony in the matter shall be collectively sworn, excluding attorneys licensed to practice law in the state of Florida unless they intend to present testimony. Those wishing to speak solely as participants will not be required to be sworn. That means members of the public, I do not require you to be sworn. Are there any attorneys here who will be speaking today or representing the applicant? No. Okay. Good, because, I mean, these attorneys. Then in that case, I do want to follow the
Need to swear us in.
I do want to follow the code section, and I'll ask that that the applicant and staff and witnesses requesting to provide testimony here should be collectively sworn at this time. Can those persons please stand and raise their right hand?
All right. Raise your right hand. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth during this hearing on June 5th, 2026?
I do.
State your name and address for the record. It says on the paper.
Yeah, I know.
We're gonna.
We won't do that. Yeah, we'll get into that when you come up to testify. So I only had 4 people stand up and raise their hand. Is there anyone else who's going to testify on behalf of the applicant or the staff who hasn't stood up and been sworn? All right. So let's see. The next question, next section, 2-55 subsection B. The chair shall request that any individual, group, or person representing an individual or group who has applied for party status, place their name on the record. We don't have anyone like that. The county attorney shall poll regarding ex parte communications.
So, Special Master, have you had any ex parte communications about this case you need to disclose for the record?
No.
Thank you.
Thank you. All right. The next subsection is D, introduction. The staff shall present a brief synopsis of the nature of the application and introduce any additional exhibits which are not already included in the agenda backup. And before staff does that, I just want to make sure we're on the same page about what procedures should apply. And so I take it staff and applicant are in agreement that the quasi-judicial section that I'm talking about and have been following is how we should handle the hearing today.
Excuse me. 100%. The only reason I'm pulling my microphone forward is because I did not give her notes to the coordinator's notes. This is an overview. There is no additional documentation being presented today. You have everything in your packet.
Okay, so pursuant to the section, you're basically telling me that I've already got everything in the agenda packet. It's been made public. There's not going to be any other documents.
Correct. And actually, this particular PowerPoint is in your packet as well.
Okay, and can you put your name on the record?
I'm sorry, Joanna Katu. I'm the Deputy Director of Growth Management.
Great. And does the applicant have any objection to the procedures we're following today?
No, sir.
And can you please put your name on the record?
Chris Carollo.
And sir, would you mind just coming up to the microphone and putting it on the record?
Chris Carollo, owner of Lecanto Sand Mine.
Spell the last.
Carollo.
It's Carollo?
Yes, sir.
Okay, thank you, sir. And I'll also ask staff, so my understanding is that the primary applicable code section here today is in LDC 4800 regarding the fact that you have to have a special master hearing when there's an application for an extractive use that leads to a PUD.
And extractive use that does not have a current extractive zoning, correct?
Okay, and we'll get into that a little bit. So, all right, then I will. Was that your introduction, Ms. Katu?
No, she's
Okay,
got slides.
then I'll
She's
let
got
you
a
do that.
PowerPoint.
I'll let you do that.
Go ahead. So this, go ahead, Liz. I can't move it, so you're going to have to move it.
The notes have finally appeared.
They've showed up.
I
Oh,
can-
perfect.
I
Okay.
can take over.
I am not
from you.
speaking. It's all her. Thank you.
Thank you. This application proposes to revise the future land use map and land development code atlas map to extractive to allow for a new sand mine. A portion of the site is already zoned extractive, and there are some areas with historical mining uses on the site as well in the area. The application site contains approximately 70 acres and lies south of West Homosassa Trail and west of the Suncoast Parkway. The surrounding area contains mining operations, an outdoor shooting range, and some residential uses. This is looking west on McClure Point. The existing mining access is on the left in this photo and is the most northerly portion of the application site. This is the intersection of McClure and Race with the application site on the right behind the large berm. Outside of the existing mining area to the north, much of the site is vacant with natural vegetation in place. This is the overall mining plan to be completed in 2 phases. The 100-foot buffer is proposed around the perimeter of the site. Thank you.
Does that conclude staff's introduction?
The introduction, yes.
Okay. Then the next subsection, E, talks about the applicant presentation. The applicant shall make his or her presentation, including any witnesses, experts, and/or exhibits the applicant may wish to present as testimony. Sir?
Hello, everyone. My name is Chris Carollo, and my family owns Lecanto Sand Mine here in Lecanto in the Preach-Fraser Hall area. We are here today requesting a land use and zoning change to extend the existing extractive designation to the remaining portion of our property. Peach-Fraser Hall is approximately a 350-acre area which has historically consisted of extractive properties along with some low-density residential homes and mined for over 50 years. Much of Citrus County has been built from the materials that come from properties like ours in this area. Many homes and businesses in the county are built on foundations made from our sand, and even the Suncoast Parkway expansion is using material from our property. I also think it's important to understand that extractive use is not the end of the story for these properties. It is the beginning of the future of opportunities. Once extraction is complete, these lands can transition into valuable future developments that benefit the county and its residents. In fact, other extractive properties nearby have already evolved into successful community uses, like the Outpost Shooting Range, Johnson Family Hobbies, and as we are requesting our final use to be a landfill, where it will further support the community. We understand that there are people that oppose growth and development in Citrus County, and we respect their rights and their opinions. But we believe we have met a very stringent rezoning and mining code standard, and we respectfully ask for your support and approval for this request. Thank you for your time and consideration. Be happy to answer any more questions, sir.
Okay. Do you have any witnesses who you wish to offer in support of your application?
We have our engineering firm with us for any technical, but nothing that we'd like to put forward that's not in the packet right now.
Okay. So you have no further witnesses?
No, sir.
Okay. Does the staff have any comment?
I have some questions, yes, okay, this is the time? All right, and these might need to be by your engineer, but it's up to you. A couple questions. So first of all, it looks like in this report, but it is a draft report, it says that you're not expecting to impact the water table or actually come in contact with that. Can you elaborate on that a little bit?
Yeah, absolutely. We did extensive boring on here. We actually did the borings required for a full ERP prior to even doing the zoning. So we were able to do seasonal highs, drilled it, found out where the water table is, went above the standard of 5 to 10 feet and used 15 feet above that as our minimal depth. So that's where we're actually able to come in, find our dig depths and excavation amounts.
Okay, and then as a follow-up for reclamation, I don't think your ERP is approved yet, is that correct? Okay.
Not yet.
I know you have a reclamation plan in the packet. It's not very specific, which it doesn't have to be at this point. But can you talk about reclamation and what you think would be in place when you're finished? I saw that phase 2 can't start construction until phase 1 is reclamation is finished, but what are you planning for this?
So finalize bringing it back to as close to the environment as it possibly can. The end-term use here is going to be hopefully selling it to the our southern neighbors there, which is a C&D landfill. So if we went through, we did the process of the rezoning and the PUD, have it permitted, do the sale to them, it would then be their responsibility to do the liners and the ventilation systems and then put it into operation.
Okay, so you may have some lakes then, is what you're thinking, but you're going to have also some pasture areas, and there's a lot of protected species here. So that is one of the items that you would have to restore with the ecosystem. So what's proposed for those?
Bringing back in the original trees that we could. We're trying to save as much around the border as possible. The gopher tortoises, obviously, we did that survey already and have a relocation site set up for them once it's ready for the ERP. But yeah, as far as when it's finished, very well groomed, 4-to-1 side, 4-to-1 slopes, grass growing back in, so it's ready to transition into its next use.
And the one deviation in the staff report that I know you've seen is the I don't think that's me, but is the setback to extractive activities for residential lands, and you do have some residential committed property on either side of you. So how are you going to be addressing that?
So with that, we followed the original on our active mine is 50 feet. We doubled it to 100 feet per what the code of mining to the county, as well as what the Swift Mud standards are for here. It's a very low residential area. We've already gotten a verbal from the shooting range that they would do a waiver if necessary, but we are looking to do a 100-foot buffer instead of the 500.
Okay, so the houses that are on either side, it's not that you're getting a written consent for those houses?
So we will approach them and ask for the written consent also, but we would like to go for the deviation for the 100 feet there.
Okay, I think it's like 150 on your east side because of the street, but okay.
Yes.
All right. Have you seen the conditions that are in the staff report, and do you have any concerns with those?
No, ma'am.
Okay. I have no other questions at this time, sir.
Okay. I have some questions questions. So help me understand the request on the 100 feet, because unfortunately, I haven't memorized everything in the code. So what are we talking, I think you mentioned from 500 to 100. What does that mean?
If it has to do with a residential property, excavation shouldn't take place within 500 feet of that. A lot of that was for dolomite and phosphorus. I think 200 was for sand and other materials. I have to check on that. We used the 100, which was set by the county code ordinance, as well as by state SWIFT MUD to follow there. If this was a different location with more residential, I think that the larger one would be appropriate. But due to the background of this one and the surrounding area, we are asking for the 100-foot.
Okay. And you mentioned in the discussion on species, and I remember in the packet there's really a kind of comprehensive examination of gopher tortoises. I've never seen such a comprehensive examination, honestly. I learned a lot. But you also talked about original trees and bringing back, what is it? How can you bring back original trees or preserve original trees?
The biggest thing is going to be in our buffers, in our setbacks, where the original is going to be in there. Obviously, you have your downward bowl shape, which is going to be any sand mine or borrow pit, which it needs to be for the final product to be a landfill. But with anywhere that's not touched, it would be brought back to its original nature ecosystem. Down on the slopes, we do everything to maintain them with the sod and the grass until the next owner came in and decide what they wanted to do with them.
Okay, so you're not saying we're plucking trees from the middle of this property and we're going to bring them back?
No, sir.
Okay,
No, we can't it's just impossible to do that.
Yeah, I think so too. I want to make sure I understand the nature of the contiguous properties. So does your entity own neighboring property to the highlighted property on the screen, or just this property?
Just this property, sir.
But some of it is already zoned extractive.
Correct.
Now, I'm just curious, if all you were doing was seeking to mine the property zoned as extractive, do you have enough space to do that? Or do you need this additional property in order to even do any kind of mining?
It adds a significant setback, an almost an unrealistic one of 500 when you start collapsing it around on all sides. As you can see, the southern border, that's industrial. The northeast and the north are mining and industrial on the gun range there. So to follow the contour straight down south there and to be able to maximize it, that's what we would like to do.
Okay, that makes sense. You mentioned, I think in your introduction, that there's sand already being used for the Suncoast Parkway. Where is that coming from?
So not this moment. We actually had to renew the ERP on the 25 acres. The northern portion, the top 5 acres, has been mined for probably 20 years.
Okay.
So
The northern part that's highlighted there.
yes, so
Gotcha.
yes, right where that line comes across, which you can't see, there's 5-acre parcels
Yep.
that have been mined for about 20 years.
Okay.
They've had various owners. That was part of why we bought the property, because it was shovel-ready. And then we would go into and do an extension of the property, which is a lot more acceptable than doing a brand-new EXT zoning.
Okay. Just looking at my
And actually,
notes.
the property to the northwest, that 10 acres I just purchased, so we actually own that one too,
As part of this entity or another entity?
this entity.
This entity. But not a part of this application. And, I mean,
No.
what's the zoning on that property?
EXT.
EXT.
Yeah, so that one's just, it's already EXT, and we are filing a new ERP.
All right. And so sometimes I'll be looking at my notes. I may have pauses as I consider questions. One of the other things that is true for my job in this hearing is to determine whether or not the proposed use and change is consistent with the comprehensive plan. So I look at, I don't know if it's called Chapter 17 or Section 17, but there's certain objectives and policies in there, and that's kind of what I think about. So I think what I'll do is I will pull up that very quickly so I can ask you some questions now instead of waiting till the end. Chapter 10, yeah. Oops. Yes. Goal 17 in chapter 10. Listen, there we go. All right, so goal 17 talks about the future land use plan is intended to enhance the quality of life of the citizens of Citrus County through adequate housing, services, and facilities, protection of the environment, creation of favorable economic conditions, and the elimination of incompatible land uses, hazards, and nuisances. And there's a section, Objective 17.1 talks about growth and development, which I think you've already kind of testified to, that this would have some opportunity, and certainly after the use that we're talking about here is complete, it would have some service to the county, possibly as a landfill. So that relates to a question. I mean, have you already had discussions with your neighbor to the south about acquiring the property?
Yes. We've had several discussions with them. At this point, they're very interested. They want to buy a piece of property that is ready to dig into. That's what is appealing to them. The location that it runs directly on their northern border is huge. And they're starting to get full on their end. They're actually coming to capacity probably in about 2 to 3 years, and that's the timeline that we're looking at to end mining there. It would be about 2 to 3 years to deplete this size of a sand mine.
Got it. There we go. And then scrolling through, eventually there's a lot of objectives here, but objective 17.13 is the county shall allow the economic recovery of mineral resources while protecting its citizens and environment from adverse impacts. And then under that objective, it kind of gives some guardrails for what that means, because standing alone, that objective basically says people who own property that have mineral resources should be able to take advantage of that. And then, but the policy, as it says in determining that, is 17.13.1. The county shall provide for the use of mineral resources and the reclamation of mined lands through the county LDC. It does that. There's sections that talk about that. I don't need to worry about that. Policy 17.13.2. There shall be no further new mining operations allowed in the Withlacoochee State Forest. Is this in the Withlacoochee State Forest?
No, sir.
So I don't need to worry about that. Policy 17.13.3. The county shall notify all new residents locating within 1,000 feet of land designated for extractive uses of the existing or future mine. For the purposes of this hearing, has the county done that?
No, that would be if the application is approved, and then that would be as part of building permits.
Okay. And I also find that I don't think that's necessary for this hearing. I would, if I did make a recommendation regarding this that was in favor of it, then I would require that all conditions be complied with in the comp plan and the land development code. That brings us to policy 17.13.4. Resource extraction will result in an adverse effect on environmentally sensitive areas which cannot be restored, shall be prohibited. It gives some examples, talks about wetlands, rivers, streams, lakes, springs, etc., but it also says later on that the county shall prepare an inventory of the environmentally sensitive areas described in the policy above and important mineral reserves. Does the county have such an inventory?
We have a mining map, but no, we do not have such an inventory.
Very good. What that is relevant for me is that one way of reading this code is to say that unless it's on the inventory, it can't be considered environmentally sensitive, because there is no inventory. I think that's done on a case-by-case basis based on the non-exhaustive list of things. So I want to ask you, sir, a couple questions based on what the code says. Are there any wetlands on this property?
No, sir.
Are there any rivers on this property?
No.
Are there any streams, lakes, springs, or coastal floodplains on the property?
No, sir.
Is there any habitat of threatened or endangered species?
The only one would be the gopher tortoises, which would be relocated.
Are there any prime agricultural lands?
No, sir.
This may seem, but I want to just
Absolutely.
develop the evidentiary record for my decision. Is there any prime groundwater recharge area?
No, sir.
Are there any historically significant sites, in your opinion, on the property?
Not that I'm aware of, sir.
Okay. Let me just see here. Is there any other provision of the property that is environmentally sensitive for some reason?
Not that I'm aware of, sir.
And I do find, I mean, there are, as I said, several photos in here that kind of give a pretty good idea of what the property looks like from top to bottom, as well as aerials that kind of give an idea. You know, there's an inventory of plant species, I think, that are there and around there. Well, let's talk about the restoration. Let's assume for a second that it was, for some reason, I think the only reason on the record that it would be considered environmentally sensitive is the presence of the species. Once the gopher tortoises are removed and it is made a landfill, let's say later on, just hypothetically, I have no idea what it'll become. Is there any way that the property would be able to be used by gopher tortoises again?
Absolutely.
Okay, and how?
They definitely leach back in, you know, into properties when it's undisturbed. They naturally move back into them, and I think that's why it's required by SwiftMud that you do this every 3 to 6 months. When you do have an application, you have to go do a new survey because you'll get new environmental.
A new gopher tortoise survey?
Yep.
Okay.
So if our survey out there, if we don't remove them within 3 months of us doing the survey, we're going to have them go out there and do an updated survey. So that's something that's done with SwiftMud because they know that they're very transient animals. Mm-hmm. So would the environment retain back there? Yes, and the animals would reflow back there.
Do you know if there are gopher tortoises on the neighboring properties?
From what I've seen, yes.
Just curious.
From what I've seen driving in quite a bit, because you see them in the berms along the way, and you can just see their puffs of sand as you're driving by.
Because it seems to me that it would be difficult to have them come back if all the neighboring properties also ended up being developed. Then where do the gopher tortoises go? Look, my job isn't gopher tortoise special master, but I'm just curious about how it does get restored in the process. I'm amazed that there's as many of them as there are appearing to be. I mean, this is
See the count?
yeah, 156 or something like that.
Significant.
So, all right. So going through the code section. Let's see here. Okay, well, that's it in the comp plan. So I'm going to go back to, I don't have any further questions for you. I don't know if the county does.
No. Clarifying, thinking about the inventory, you caught me off guard a little bit. I am not aware of an inventory. There could be one in our files, but I'm not aware. I did not provide that to you today.
That's okay. I mean, I think it's important
Perhaps, yeah.
if the property was on the inventory, and I'm kind of skeptical it is or would be, but if it was, then that would potentially change the analysis. But again, just based on the evidence that we have, I'm not sure, and I think it's distinguished from some of the other properties I've seen maybe that have applied for this based on contiguity with other properties and the nature of the environmental sensitivity. Plans, I mean, again, it seems to me from an evidentiary perspective rather exhaustive in the application about species. I mean, even indigo snakes, I think, that can sometimes burrow with the gopher tortoises. So anyways, I don't have any further questions there. There is no party. So, sir, I appreciate it. Thank you. I have no further questions. We go to the general public, so I want to hear from the public, unless the county. Oh, I'm sorry. Yeah, go ahead. My bad.
All right.
Subsection F, staff presentation. There we go.
I kind of like being skipped, to be honest, but
Join the club.
all right. So this is the application side. I put up the Land Development Code Atlas here. I probably should have put up the future land use map instead, but it's in darker bold is the application site. So you can see that the very northerly parts right here, the striped is already extractive. These three lots right here, the three most northern, although it says low-density residential on the atlas, they're actually extractive on the future land use map. There is an inconsistency there. And in the staff report, I did talk about his history on those. They do have a history of some extractive use. We know there was extractive use there at least in 2006 and 2008 when they applied for a vegetative grinder. The grinder is not the issue here. That
Vegetative grinder?
yeah,
Oh, to
yeah, to grind up with
grind
their.
up, okay.
That's not the issue here. That was put in there because it's demonstrating that at that time, 2006 and 2008, when they tried to appeal the conditions, they did know that there was an associated extractive use on site. So those three lots we know of had some extractive use in 06 and 08, regardless of the grinder status. That was brought up quite a bit, but it's simply. Yes, we know back in 08 and 06 that was there. The reason that's important is we have an active code compliance case, which will be going to an alternate special master for these sites because there's been a claim that because they're non-conforming, because low-density residential, they may not have been in historical constant operation. So the
Can you repeat that?
Sure. They're non-conforming because the low-density residential designation on the Atlas map. So even though in 2008 we know there was extractive, they would have had to continue without any break of more than 365 days to keep that vesting. And the complaint is that they have not. So I know the owner is working on trying to get documentation to fight that. It is being scheduled for the alternate special master, not yourself, because you're doing this one. So that's coming forward. So that's in the process. I know they're working on that.
I know that the alternate will be there at least in October. Would this be before the October?
We're thinking probably August, yes, unless they can demonstrate that has been consistently, and they're working on that. So that's just an aside for those three lots. The rest of it is low-density residential on both maps. You can see the low density around it. They do have industrial to the south. They have extractive to the north. And then you can see the parkway, of course, is a big addition there on this map.
Not to interrupt
Sure.
unnecessarily,
Yeah, you're fine.
but I will forget things if I don't
No,
ask.
please do.
So,
Thank you.
Previously, the county has articulated policies to me in my capacity as a special master for code compliance that when there is a pending code case, it won't endorse certain other applications or changes or permits sometimes. I may be misstating the policy, but do you know what I'm talking about?
I think
Does it impact the county or staff analysis on this at all that there is a pending code case?
it's there. The validity hasn't been decided yet. I think what you're thinking of is how we don't allow our RVs, for example, if you're cited for an
Right.
RV.
That
Yeah,
is
on
what-
that particular one, that's a very specific thing.
Okay.
Yeah, even if you're in code, a lot of times, not a lot, but sometimes zoning cases are to mitigate a code case. So we do want to keep them going because, for example, this one, if this gets approved by the Board of County Commissioners, the code case is abated because the mine can continue.
I see. Okay. I
Yeah,
understand.
so that happens sometimes. Not I should have said all the time, but that happens a lot. The zoning cases are trying to mitigate code cases.
Because I might think that if there is a violation of the land development code, that's not consistent with the comp plan, so that could be an issue. But if you're saying that if I made a recommendation and the board approved that,
Right.
then the case goes away.
Correct. The
Okay.
case would be abated because that having to prove it's been mined all the time doesn't matter. They're now approved for mining.
Understood.
Yeah.
Unless it's an irreparable harm.
Whole different legal world, but yeah.
Okay.
Yeah, in this case, we have evidence of the mine at the top where you see the pictures, and you'll see them again.
Okay.
So looking at the area, there is a lot of extractive and industrial type uses there. We talked a little bit about the mining activity with landfill. Let me say that this is not a landfill application. We're not considering a landfill use here. That's not allowed as part of this. This is simply for mining. To the east is an outdoor shooting range. It is very large. That's why the large print, it takes up quite a bit of many of those parcels. To the north is an active mine. To the northeast is an active mine. To the west is a proposed residential subdivision that is in hearings right now. They should be starting hearings later this year. So they are aware of the mine. That is that. Now, the blue stars I have there are residential homes. So that's what I was trying to focus on here is you do have to have a 500 foot from extractive to a residentially committed property. They're not meeting it on this part. They would have the 100 foot buffer. That's where he's asking for the relief. The code also says you can get a signature from this person. Verbally, they told me they had talked to this person and they think they can get that, but that would meet that condition. Same thing on the east side. This particular home right here, you have a road and the 100 foot buffer, so that's about maybe 150 feet instead of the 500. Again, they can get a letter from that. They think they can get that. That would deal with that residential that I'm talking about. The others are just there for FYI. There's some houses over there that, they're right next to the parkway, but they are farther away from the 500 foot in our code. So this is the road that accesses it right now. On the right is actually an existing mine site with their berm. You would never know it's there, but it is definitely there on the other side of that berm. I did not walk to the top of that.
So you took these photos?
I did take these photos, yes. So this is looking west on the same street. North and south, apologize. Same street, you've got some mine. The shooting range is off to the right out of the picture on this site. And this is Race Avenue that comes down. You're right at the corner. So if I'm looking at this picture, on my right side on the screen here is the entrance to this proposed mine here. There is in the corner up in the north, this is the shooting range start, and this is a mining activity here, and there's another mine down at the end here. So although these roads are not improved, this is certainly very much a mining truck activity area. This is one of the entrances to the shooting range. This is right across the Race Avenue site from the, let me clear. So if the mine is right here, the shooting range, I am right here. This is the entrance to the shooting range in that picture that I'm showing. It's not their main entrance, it's one of their back entrances, but they are right across the street with some wiring and certainly some activity. And this is the end of the road of Miller Run. The landfill that you were talking about is on the other side of this fence. So I know it's hard to, it's hard to show where I am right now. So I am right at the end of this road here. So that's that dirt pile. The shooting range is here. And the pictures I was taking were right here on this street, and then you go down this street. And
Is the shooting range industrial?
It is industrial, yes.
Okay.
And that went through a lot of hearings at that time. It's been there for a bit. So this is the end. There's a pilot. It looks like somebody is maintaining the roadways. I don't know who is doing these. These are private roadways, but this is the end of Race Avenue, and on the right is the end of the mining site application. So this is their plan in the packet. You can see the phase 1 and the phase 2. I thought it was very important that they did say that phase 2 would not start construction until they're finished with phase 1 and start reclamation. That is important.
Why?
Simply because we don't want to see a site with as the policy that you read, we want the ecosystem to be restored. So that was very important. I heard his answers about the gopher tortoises. I agree. You cannot restore it to never being a mine there. But it is important to restore the ecosystem, the grasses, whatever water they're doing, but also to allow those gopher tortoises back in there and the other species.
And you think that's, you have no evidence to contradict what you heard that gopher tortoises could return to the site?
Right, I do not. Even fences don't seem to stop them very well, which is great. I'm glad. You also saw in the report there's a lot
You know
of.
how we feel about animals.
I
Okay,
know,
so-
and believe me, I do for gopher tortoises especially. But there's a lot of invasive grasses that you saw in the report in the detail. So much so they recommended burning them when they removed them on the border. Those, a mining truck from long ago might have put those out. But there's a lot of positives, but also the reclamation plan is very important to restore that ecosystem and try to get there. This is not a environmentally sensitive area, but it definitely has its own ecosystem with the sandlands.
You mentioned the reclamation plan. I thought when you examined the applicant that you implied it was like maybe not a detailed reclamation plan? I mean, do you normally expect more?
Not at this stage. We do certainly for permitting, but it is dependent on their ERP, and the state can kind of take what we say and do their own thing. I would like to have seen more at this point, but I don't have to.
What more would you have wanted to see?
I would have liked to see a little more detail that this is the area where we think the lake's going to be, and this is an area where we're probably going to have a berm here, and we're going to have pasture here. That kind of detail would have been nice, but I know it's all subject to the ERP.
Okay, thank you.
So this is showing the berm that the buffer that they're proposing. Now you saw in the pictures they do have quite a large berm already in place, and they are proposing that throughout the site as well, in addition to this buffer. And I'm not really sure what I was trying to pose here, but this particular one I wanted to zoom in. The reason I wanted to zoom in is because that text is very, very hard to read. But what it talks about is they're also going to have fencing and signage in addition to the buffer that is required in the Land Development Code. So this is their confirmation that they are meeting that standard. So looking throughout the application, they do seem to be meeting the standards in the Land Development Code for mining. They're meeting the safety and security with the signage and the fence. They have the acreage. They have the screening. They have the days and hours of operation. They have the surface waters and wetlands criteria. They have traffic circulation and reclamation, what they need for this point. The only thing was the deviation, and that was the only thing in the entire Land Development Code that I could see that they're not quite jumping through the hoop for.
And to that effect, I don't know what else you have, but could you go back? That one right there.
Mm-hmm.
So if we followed without deviation based on where the residential properties are, it seems to me that it would substantially eat up almost any mining ability in the south of the property, assuming north is at the top of that and south is at the bottom. I mean, what is...
Yeah, you're right. It wouldn't come entirely, like this one is 150 feet, so they would need to go another 250.
You'd at least triple that green space
It'd
down
go
there
to about here.
on each side.
Right. It definitely would. So if that was not granted, they would need that letter from those owners on either side to be able to do that, yes.
Okay.
And that's really all I have. There's a lot of conditions that staff is recommending
What are
in the
those
staff
conditions?
report. Sure. Let me go over those. So number 1 is applicant shall adhere to the master mining plan for sand mining only, clarifying this is not a landfill, as outlined on the site construction plans dated March 6, 2026, and accompanying documents providing a total mining extraction area not to exceed 70 acres. Number 2, the days and hours of operation are limited as follows, and these are from the Land Development Code: Monday through Friday, 6 a.m. to 6 p.m., Saturday, 7 a.m. to 12 p.m., and Sunday, no mining operations. There's also some clarity in the Land Development Code that, if you have to repair something, fine, but you can't go out there and start backing up stuff outside of these hours, et cetera, with the backup lines. Condition number 3, applicant shall secure the areas of excavation by installing and maintaining fencing, which shall be at a minimum field fencing no less than 4 foot in height and posted with no trespassing signs every 100 foot and at each corner of the property. That's what was on that one slide. Condition 4, applicant shall address and provide protection for any protected species on site prior to commencement of development, including any state, federal permits that may be required. That's specifically they go for tortoises, but if they do discover any other species as they're developing. Condition 5, there should be no blasting, processing, preparation, crushing, cleaning, or screening of material on site. That's actually quoted from the application as well, that they're not going to do that. Condition number 6, at time of permitting, applicant will need to provide certified boring lots to the county for the area being excavated. A plan showing the boring locations will need to be submitted to the county for approval prior to the borings being made. This is something our technical services reviews as far as looking for stormwater issues. Number 7, applicant will need to provide proof of swift mud permit approval to the county prior to starting excavation. Number 8, applicant will be required to apply for a right-of-way utilization permit for any right-of-way work on any county-owned roads. It's a very long condition. It talks about being responsible for damage with construction, traffic, etc. I don't anticipate there's going to be right-of-way work on county roads, but there may be, so that's why this is a standard Condition number 9, a minimum 100-foot natural wooded buffer shall be installed around the perimeter of the site. If the buffer area cannot be the equivalent of a Type D buffer without a wall, as outlined in the Land Development Code, additional plantings to a Type D equivalency will be required to mitigate impacts to surrounding areas. That actually is in their construction plans word for word. Condition number 10, at the time of permitting, the applicant shall provide an updated seasonal high water table investigation report that complies with LDC standards and remove all erroneous references to Hernando County on the construction plans. That's some typos on there. This is the one I talked about that's stamped draft that says they will not impact the water table or doesn't appear to be. We definitely want one that's final, that doesn't say draft. Condition 11, the PUD shall remain in effect for the life of the Environmental Resource Permit, or ERP, issued for this use, provided all the terms and conditions of approval for the requested PUD are in compliance. That is normal for a mine. Condition number 10, where standards are not specified, standards in effect in the Land Development Code shall apply. And finally, minor modifications may be approved, subject to the terms in the Land Development Code. Excuse me.
Okay. Okay, yeah, please.
I have no other items to present.
So as part of this hearing, my understanding is that I essentially need to make a recommendation. And part of that is consistency with the comp plan. And I've kind of walked through that. But I noticed in the application, there is the mining permit application checklist. And I think it went one by one following LDC 4800 G2D, which has all the elements of what that would need to include in an application. Do I need to know what a permit application has at this stage to determine consistency with the comp plan?
You are part of the permit application review process. So in that case, in that way, kind of. I'm sorry, I'm not saying clearly yes or no, but some of the construction specifics we're not going to have at this stage. But you do need to have the basics on there because this is part of the mining permit approval.
Okay. So when I look at section 4800 G2D, it lists a bunch of things that have to be in an application for a mining permit. And I'm just going to walk through for the benefit of the county and the applicant, and we'll just talk about it, okay? The first item is a site and development plan drawn to scale showing all setbacks, buffers, fences and gates, structures, access drives, and associated operations on the site. And the response from the applicant is site plan attached, Exhibit C1. No structures are proposed. The site will be silt fenced with buffers. Do you have any reason to disbelieve that?
No, that was a good answer.
I agree. So you find that consistent with subsection 4800 G2D1?
Yeah, it meets those standards, yes.
Okay. G2D2 talks about an aerial photograph with property project boundaries shown depicting existing site conditions, certified boundary and topographic survey to 1 foot contours, feet NGVD. The response is boundary with GIS topo plan attached as Exhibit A. Is there any reason why the county believes that would be insufficient?
No, that was adequate.
I agree. Number 3, all filing requirements for a PUD or application for land use change as required above. It says Comp Plan Land Development Code Amendment and Atlas Amendment applications attached, which is a slightly different thing than PUD requirements.
They're rolled into one application type.
They
So
are.
in this case, that would meet it, yes.
So the county satisfied that all filing requirements for the PUD or application for the land use change have been provided.
Yes.
Okay. Number 4, provisions to demonstrate that erosion control and stormwater management measures are taken to prevent silting of drainage facilities and water quality violations in receiving waters. The answer is all land will be sloped toward the pit, no water will leave the site, so there is no chance of water quality violations in receiving waters and no chance of silting in drainage facilities. The pit itself is a stormwater treatment facility. Do you have any reason to disbelieve that?
No, I should say that what you're reading is the second version. So the first version, we gave all the staff comments, and most of these are good after talking
I
to
see.
them.
Okay.
So they are, yes. Also, their construction documents included this information as well.
And from what I've seen, by the way, I honestly I don't see any reason to disbelieve any of this. I'm just putting this on the record. I want to
Understand. I
discuss
appreciate
it,
that.
and there may be questions from others. So the next element, a fugitive dust control plan that demonstrates compliance with site work requirements of this LDC. The response is fugitive dust control is located on the CSWMP plans attached Exhibit I-1 and I-2. And is this sufficient from the county's perspective?
Yes. They have I-1 and I-2 in the packet.
I agree. The next item is a reclamation plan for the mined area and all associated operations shall be provided, if not previously approved within a master mining plan. It shall show, and there's a bunch of things, but the first response before we get into those things, reclamation will be conducted in accordance with the ERP that has not yet been issued by SwiftMud. A proposed reclamation plan is attached on exhibits F1 through F4, and so that's the reclamation plan that we've been talking about where all things being equal, you would have liked to have seen more, but you recognize that that's actually dependent on something we just don't have right now.
That's perfectly accurate, yes.
Is there any reason why we should have had it by now?
No, it's not required at this stage. Again, it would be nice, but it's not required. The ERP is going to be the ERP, but the reclamation information they give us in the packet is very helpful, although maybe changed.
I'm sorry, what was that?
The reclamation information they give us, the ERP is going to tell us something that may be different. I don't expect there to be a lot of changes between them, but it's a good start. I just don't have all the details.
Okay. Then the next part, and I'm looking at page 17 of the packet, master mining plan requirements, LDC 4800 G3. First of all, it talks about all filing requirements for a mining permit. The applicant says see above. The next item is phasing of excavation activities, including a site plan showing mining units and locations of processing and affiliated facilities. Response from applicant. Mining will be phased in 40-acre due to ERP requirements of maximum. It is anticipated that over the permitted 40 acres, different pits at the same time because of variability in sand quality. Sand will not be processed. The sand will be dug, put into trucks, and placed on projects. Phasing map exhibit C2 attached. Now, I think the county's condition is that a maximum of 70 acres. Is that a county condition?
It's 70 acres total for
Total.
extractive, right. But
Across phases.
right, with the two phases. And the phases, if this is approved, would be part of the ordinance approval with the phasing.
So the response is mining will be phased in 40-acre due to ERP requirements of maximum. Are we able to know right now, and I'm not sure it matters, but are we able to know right now if it'll be 40 and 30, 35, 35, anything like that?
We have it right there in the green and the pink, so we can see that the
40
phase
and-
one is the larger. Yeah.
Yes, okay. I'm just reading this. This might be a question for the applicant, but I guess my question is, based on the phasing, does mining only begin in phase 2 once it's complete in phase 1?
That's what it appears to say in the text, yes.
Okay. I'm seeing nods of the head. Okay. For the record, the applicant says yes. Next item, groundwater monitoring and reporting plan that meets the requirements of FDEP and SwiftMud rules for groundwater quality and groundwater levels. This project will be permitted through SwiftMud, not FDEP, and any monitoring required by SwiftMud will be performed and provided to the county. Does that satisfy the county?
Yes, sir.
You know, it would just be a shame to have all these requirements and not actually walk through them.
No,
Wouldn't you say, County Attorney?
I appreciate it. No, thank you.
Okay.
I didn't, and I appreciate that you are.
Pollution prevention plan. I'm not going to read the whole thing, but the response from applicant is a stormwater pollution prevention plan is attached exhibits I-1 and I-2. I've seen that. Does the county have any reason to think that's insufficient at this stage?
No, it was fine. Thank you.
Then the next section talks about biological and geotechnical reports. It says attached are items required for biological and geotechnical reports as outlined in LDC 4800 G4. One of those is that a biological report that meets the FWC standard shall be submitted and approved by the department prior to approval of any master mining plan. A biological report is attached. I've read that. Does the county have any, believe there are any insufficiencies with that report?
No, sir.
Next, a geotechnical report shall be provided with any master mining plan or mining permit application. The geotechnical report shall evaluate the potential for impact on water levels and water quality in any aquifer to be impacted by excavations or affected by dewatering during the mining operations occurring after the effective date hereof and shall contain the following. Geotech report shall be performed by a professional engineer or professional geologist. A seasonal high water table summary report performed by Creative Environmental Solutions is attached. Ms. Coutu, do you have any reason to think that that report is insufficient?
Only because it has a stamp of a draft on it. I would like that to be off, but otherwise, no.
Is the person who prepared that report here today?
Ask them. I'm gonna sit down while we.
Yeah.
Central testing labs, we can absolutely get it.
And I'm sorry, so if you could speak on the microphone, just because then all our
Sorry
viewers
about
can
that.
hear.
That was Central Testing Labs, not our engineering firm, but we can get that where it doesn't say draft on it.
I mean, do you have any reason to believe that it would be changed in any material or substantial form from the draft?
No, sir.
Okay. Would it be identical?
I'm thinking yes.
And you've been sworn in, so could you put your name on the record?
Yes, this is Boston Tefelsky with Pro Civil 360.
Okay.
My last name is Tafelski.
Thank you.
So we have an official geotechnical report conducted by Central Testing Laboratory. I think it was like 5 or 6 borings across the whole site to determine the highest seasonal water table. That water table was established at like 16 feet. Due to our nature and experience with sand mines, we applied a safety factor of 15 feet. So we're at the 30-foot elevation is our lowest that we're digging to.
Meaning you've determined that the highest the water table would be is 16 feet, and then you're saying, look, we want to be safe.
Yes.
We don't want to play games.
Exactly.
And you're adding 15-ish feet to that, saying we're only going to go down to 30 feet.
And that is due in large part to a big surface area of recovery for so much watershed going into this pit. The recovery slows down. So that extra filter between the seasonal high and the bottom of the pit will allow the water to take up the voids in that filter area.
What does seasonal high mean?
Seasonal high means that there's a groundwater table. That's where permanent water exists permanently. But the seasonal high water table fluctuates with peak rain, such as in July here. So we'll see the water table rise in the rainy season. So that is the highest that the.
Well, I want to tell you 2 stories and then get your feedback.
Yes, sir.
One time up in North Florida, I was in a truck and we saw some wet mud on the property, and we thought, with 4-wheel drive, we thought we'd be able to handle that mud and we wouldn't get stuck, and we'd never been stuck before, and we tried to gun and we got stuck. And as the day went on, it felt like the water was actually rising around us. Like it felt like the mud was getting wetter, if anything, towards the night. And that was a surprise. And then about a year later, and there was a pond near that spot. It's in Jefferson County. It's just property I'm familiar with. And then about a year later, the whole pond, which was about 12 feet deep, was gone. And that was as February of this year.
Yeah.
And what I was told is that's the water table. Like, it's dry and the water's just not there. But people have commented as to the wide variability of what that level might be. So I guess what I'm getting at is when you talk about a seasonal high, under what circumstances can it be higher than that? Like, are we talking, 1,000-year kind of storm events, or what? Can you help? Do you understand what my concern is?
I guess so, but in the realm of geotechnical engineering, there is so many safety factors put on for that seasonal high water table establishment. When was the boring taken throughout the year? Was it in December when we haven't had rain in 3 months, right? Or in the dry spell that we're in right now? So that all those
Meaning that if it was taken right now, it wouldn't be that helpful
Exactly.
to know what the safety factor should be. But if it's taken when it's wet and the table should be high, we should have a better indicator of where it should be to be safe. Mm-hmm. Is that correct?
Well, those safety factors are considered when the boring was taken. So central testing, considered those factors that you're stating right now. So they were taken, I think, 2 months ago in a very dry season. So they even had their own safety factors to determine that
see
16
what you're
foot.
saying.
And then we applied our own additional safety factors on top
understand.
of that. So
Now let me tell you the second story.
yeah.
I was at a sand mine hearing about a year ago on a similar. No, it's not similar actually. The type of property I think, but and I heard testimony from Mr. Foster, and I read reports about water tables, and I had eventually made a recommendation that the property wasn't consistent with the comp plan. And I don't think it even went to the board. My understanding is that FDOT ended up taking some of the property. This is not part of the evidence. I'm just talking to you to get some feedback. And my understanding is also that once FDOT got possession of some of the property, some machinery went onto the property and became submerged. And that was despite all the testimony that we heard at the hearing that there was no issue with the water table. And so I'm wondering, how would I go about verifying that there is no water table? Like, how would I go out and determine that from the evidence? How would I determine that what happened at the other sand mine spot won't happen here?
Well, so in the boring logs, you can see the types of soil and confining aquifers that may be present. In all of those boring logs, there was no confined aquifer identified, meaning lime rock base that does not permit water to infiltrate into the aquifer, into the groundwater table. So therefore, when you dig down into that lime rock, the water is not going to go anywhere. It's going to sit there in that bowl. So we have not found that in our geotechnical report.
Okay.
Yes, sir.
I think that answers my question. Are you familiar with the other side I was talking about?
I am not.
Okay, good answer. All right, let's keep going through this then. I'm sorry. Yeah, it's fine. So we talked about the biological report. We talked about seasonal high water table. Next item, it shall use a professionally acceptable methodology establishing to a reasonable degree of technical certainty the condition elevation of the affected aquifer in a normal state unaffected by mining activity. Pre-mining aquifer conditions shall be utilized as baseline conditions to evaluate the adequacy of mitigation measures and successful reestablishment of hydrology after reclamation is complete. Response from applicant. Professional assumptions supporting this evaluation are summarized in the report referenced above. Any reason for the county to believe that's insufficient?
No.
I agree. Next item, it shall include a plan for monitoring and reporting which shall include the following. Applicant response. County will be copied on monitoring and reporting required by Swift Mud permit. I don't have any questions about that. Next section talks about financial responsibility. Attached are items required to demonstrate financial responsibility as outlined in LDC 4800 G5. Any applicant for a mining permit shall submit with the application, and any holder of a current mining permit shall submit within 60 days of the adoption hereof proof of property and personal injury and liability insurance or an approved self-insurance plan that satisfies the following. Response from applicant. A financial responsibility letter from the owner is attached. Financial responsibility demonstration will be provided at the appropriate time. Does the county have to have a full understanding of the financial responsibility at this point?
We do not, but there is a letter provided in the packet anyway.
I agree. All right, that concludes my questions. Before we go to public comment, does the county staff or applicant have any other questions of me? Or anything else they want to put in the record before I turn to the public? All right, seeing none, I would like to welcome public comment, and I would ask folks to come up Well, however the county wants to do it, I don't care what podium, but I'd prefer this podium. Sir? Yeah? Oh, okay. When you come up, deliver the yellow sheet.
Thank you. We have our ways, sorry.
If you would, sir, yeah.
Thank you.
And could you, if you would, state your name? Actually, is that, what's on the yellow sheet? I don't know what's on the yellow sheet.
Address.
All right, can you just put your name? If the address is there, we don't need to restate it. What's your name?
Tony Ayo, Beverly Hills, Florida. My concern is the buffer, okay? He's stating that he wants a 100-foot buffer, possibly 150, yet I heard that 200 is typically used. These buffers are used for what reason? To protect surrounding residential properties? They are. Okay, so when you have mining,
By the way, I'm not responding.
I'm just saying,
Yeah.
so when you have a mining activity in a sandy soil location, it causes liquefaction. Okay, and that's why we have to have a larger buffer. Okay, to protect those surrounding homes, because liquefaction can cause the home to sink. Okay, and shift. So you know there's a major liability issue in here, so we need to think about that. And if he wants to do a landfill afterwards, if you only give him 100-foot buffer right now, and then everything is dug out, right? The landfill requires 150. So where's that extra fill coming from? See, you understand what I mean? So you can't dig 100, just leave a 100-foot barrier here when you're mining, and then require it 150 when you have a landfill. Doesn't make any sense. So you have to backfill, 50 feet, which doesn't make any sense to me. Anyway, I just wanted to bring up these issues. I am part of the Stop the Sand Mine, from the sand mine that you remembered. I have had reports from other neighbors in this area, the Lecanto sand mine, that their water quality out of their wells have been decreasing. It's getting sandier or some kind of pollutants, and I told them to get their water tested. And another resident said that their well ran dry. So I've seen pictures where area photos that showed water in the older part, and that they dug down low enough that they ruptured the aquifer. That's surmising, because that would be the only reason for their well to run dry like that. I mean, I understand, we're in a dry area, but understand when you rupture the aquifer, what happens is the pressure releases and the water automatically drops. Okay, because this is what's going on. Anyway, just want to let you know these things. Thank you.
Thank you, sir. Is there anyone else who would like to speak? Yeah, right over here. Good morning.
Good morning. My name's Cody Turner. I live in the house just south of the gun range and to the right of the sand mine.
Yep.
I wrote something here. Good morning. My name is Cody Turner. I live directly across the road from approximately 70-acre property that Lecanto Sand LLC is seeking to convert into a sand mine. I am here today because I have serious concerns about placing a sand mine directly across from my house and farm. My family lives on this property with our children, horses, goats, dogs, and other animals. We choose to live in this rural residential area, and I do not believe a sand mine is compatible use directly across from existing homes and farms. I am concerned about the increased dust, noise, truck traffic that would come with mining operations. One of my horses suffers from heaves, also known as equine asthma, a respiratory condition that is aggravated by dust. Increased airborne dust from excavation and truck traffic could negatively affect the health of my well-being of my animals as well as my family. I'm also concerned about the drainage and stormwater management Following recent heavy rains, I observed roadway washouts and erosion in the area near existing mining activity. These observations raise concern about whether additional excavation could worsen drainage problems and affecting neighboring properties. In addition, I am concerned about the impact of local roads, traffic safety, and property values, and the overall quality of life of residents who already live in this area. The proposed mine would be directly across the road from my house, where I raise my children, I care for my animals, and I respectfully ask for this application to be denied, and the county protect the residents, farms, and rural character of our community.
Mr. Turner, can we swear you in?
Yes.
Raise your right hand. Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Thank you.
Okay. Do you swear and affirm that the feedback you just gave me is true to the best of your knowledge?
Yes.
Okay. Have you been asked to provide a waiver regarding the buffer?
No.
All right. Would you sign such a waiver?
No.
Okay. And is it for the reasons that you put on the record?
Yes.
Okay. I'm just curious, and I appreciate your feedback.
Not
Thank
a
you.
problem. I don't know. I do have pictures and stuff. I don't know if I can show that to you now.
No, I won't accept that.
I didn't think so.
I
don't know
I
how
think
this
your
stuff goes.
testimony tells me what your feedback is on
Okay.
it. And I have a substantial photographic record already.
Okay.
So, thank you.
All right. Thank you.
I'm sorry. Yeah, I'm sorry. One moment, we'll go off the record. Right. All right. Thank you, Mr. Turner.
All right. Thank you.
Is there anyone else who would like to be heard?
All right, my
Morning.
name is Curtis Bryant from Lecanto. I do have a letter on file for 5 minutes. I think that's part of the
You have a what?
a letter on file for 5 minutes to. As part of
You
organization.
mean you're a representative of an organization? What is the? do- I see. Okay. Just one moment, sir. That's okay. There's probably a reason for that. When did you provide the letter, sir?
It was last year, like June,
Last year?
like July. They're valid for a year.
The letter for this hearing has been on file for a year?
You don't have it because it's at the clerk of court.
Okay. Now, just give me one moment, sir.
Actually, it might have been like September, October, something like that.
Okay. I'm just reading the rules.
Yeah, we're good.
Skipped over that part.
Well,
It says 3 minutes, and then the one under it is 5 minutes.
100. It says that.
I can't even read that.
No, it says speakers representing an organization or group in attendance at the meeting up to 5 minutes. So, what is the organization you're here
The Citrus Insider.
for? Okay, then I'll let you
Okay.
talk for 5 minutes. Yeah.
Okay, I do have some documents. I'm going to read through things. If you guys need copies of those, I can provide those to you. First thing I want to put on the record, there is no existing mine site. There is no mining permit currently valid for this mine site. They're operating on a vested use rights, and they don't have any letters or anything to prove the vested use. They purchased the property July 25. The LDC requires a year-long process, or a year-long, it has to be active for over a year for them to get the vested use, and they can't prove that because they didn't own the property prior to that July date. But further, I'm going to go into Chapter 4 of the LDC 4800, under Section H, the Development Standards, Section 10D, which is page 4-43, if you want to follow along on that. That is the traffic circulation. We didn't really talk about this today. It was kind of glossed over. Under D of that section, it says all access roadways must be paved up to the boundary of the subject property. That would be the roadways coming in there. Access
Sorry,
for
what
new-
page is this?
This is 4-43.
4-3, thanks. Go ahead.
All right, so all access roadways must be paved up to the boundary of the subject property. Access for new extractive districts shall be specifically limited to collector and arterial roadways, which shall not pass through any residential neighborhood. I do have GIS data here to show that Hoskins Road, which is right off of Homosassa Trail, is a local road. It is not a collector or an arterial road. And same with McClure Streets is a local road as well, and not an arterial road. But beyond that, neither of those are paved up to the boundary. There was talk of the 2006 approval of the conditional use for the vegetative grinder. On one of the conditions number 4 of that, and I got a copy of this if you need it, access between the entrance and Homosassa Trail must be paved to county standards prior to permit issuance. 2008, that was the denial of the that condition. They applied to get that removed. They were denied that condition, so they have to pave up to that roadway there. I also have a letter here going over the vested use. So 1984, lots 34, 35, and 36 were considered the vested use rights. This is the 1984 letter. 2005, the county acknowledged that those 3 lots, which is those middle parcels there, were vested use, and those were able to be mined with vested use. The 2009 letter from Gary Madoff indicated that the northern lots 31 and 32, which are the current mine sites, those are not included in that vested use application. Therefore, they would need mining permits for that, and they have not had those mining permits there. Issue number 2 that I have here, we talked about a little bit, is the development standards. So the 500-foot setbacks, we're waiving that for whatever reason, or they're asking to waive that. It is here on page 4-41 of the setbacks. It does require 500 feet. There is an application pending for that western side for that residential development to come in. So that would be more residential, and you heard the gentleman just a second ago talking about his issue with that. Issue number 3 I have here is the comp plan 17.13.4. We talked about that a little bit, but we didn't really talk about the restoration definition. So restoration is defined as to restore the site, means to put back the same thing that had previously existed. So restore the type of nature and all of that. We talked about the gopher tortoises. Obviously, you can't really put those back. But there's also some snag trees that are there. Those are environmentally sensitive because those are like woodpeckers and things like that. If they take those out, obviously those can't get put back in there. On page 97 of your agenda packet, it shows the rural open pine. That is what this land is classified as. However, in their reclamation plan, they cited FLUCCS 183213, which is defined as improved pasture. So how do we go from rural open pine to improved pasture as being brought back to the original state? Importantly, they reference this is under the thing that says potential pine land. It's an overlap for land cover. But I'm going to read what the improved pasture stands for. This category is, in most cases, composed of land that has been cleared, tilled, reseeded with specific grass types, and periodically improved the brush control and fertilizer application. That is not the original thing there. And then number 4, we talked about, I guess the staff is okay with the issue of not having the insurance and liability processes for all those things for that number 4. That's all I got for you.
Thank you, sir.
You're welcome.
That was done in 5 minutes. Is there anyone else who would like to be heard?
Good morning. My name is Dixie Hollins. I'm here today representing Citrus County Mining Association, whose members include Citrus Mining and Timber, Inc., Chris River Quarries, Amrise, which used to be Wholesome, Cemex. All those mining companies I just mentioned are full producers of aggregate, dolomite, including sand. We all support housing industry, roads, Suncoast Parkway, et cetera, et cetera. Majority of those mines have been here for decades. And we're here to support the amendments to the future land use plan, the Citrus County Comp Plan, and the Land Development Code Atlas Map to extract the districts with planned unit development for a new sand mine. If you have any questions, we're glad to take them.
Thank you.
Thank you.
That was quick. Is there anyone else who would like to make public comment at this time? Okay. Then I will close the public participation part of the hearing, and I'll allow the applicant a chance to rebut or speak in response to those comments, or if it has anything in response to the county staff.
Thank you. Chris Carollo, again, owner of Lecanto Sand Mine, and I appreciate everybody's concern and everybody that came out here. What I can tell you is that when we came to this county, we held numerous meetings with county level, state level, doing our research to try and find out what this property could be used for. We have strived as a company to better the community. We go out of the way to maintain the shared roads when nobody else is out there doing it. A lot of the issues that were brought up here were things that happened to this property before we had anything to do to it. At this time, we are striving to meet the code, exceed it, and work with our neighbors. We don't want to do anything to cause inconvenience to our neighbors. We want to work with you. We employ over 20 people in this community. Most of us are veterans. We have families. So we are here in Citrus County to grow and to meet a standard. What I'll tell everybody here is that this is the type of company you can call us up, and if there's a problem, we're going to fix it or work with you to fix it. All right? So we appreciate everybody's time, and we appreciate the time of the board here. Thank you very much.
I do have some questions, if you don't mind, just about some matters raised from the public. And so one of the issues that was raised regards a code section that I did not, the public's correct, I didn't get around to addressing, which is in 4800 G2, I think H, but talking about traffic circulation. And in the application it says, unless specified otherwise in the mining permit, and I'm looking at page 28 of your application, the following requirements shall apply to new and expanded mines, and applicant's response is, mine connection is South McClure Point. It is an existing mining operation and a connection is existing. All truck parking and staging will be located within the mine itself. So there's a bunch of things in this traffic circulation section, 4 things. And I think your comment, when I say your, I mean applicant, truck parking and staging addresses part of that. But then there is subsection D, which talks about all access roadways must be paved up to the boundary of the subject property. Access for new extractive districts shall be specifically limited to collector or arterial roadways, which shall not pass through any residential neighborhood. All roadways within the facility shall be stabilized and maintained. Paved access connections must satisfy the minimum street construction standards and be constructed to a minimum throat depth of 300 feet on the subject property. I mean, help me understand, is this property accessed through collector or arterial roadways?
So this is a shared roadway. This is the same entrance that's been in place for the 40-plus years. So with that, we don't consider it a new entranceway, needing to be upgraded to that. This is a shared road with, I would say, 3 different mining locations that have used the same location. We have not changed our entrance or exit on that location ever.
Okay. And I mean, do you know when this code section was created? Is it possible that your access predates this code section?
Absolutely.
Okay.
I would say absolutely, because that property has been in that area since the furthest we could find was 1979.
It talks about all roadways within the facility being stabilized and maintained. Would you be complying with that?
Absolutely. We have to, or the trucks would get stuck.
I'm just looking through this section. I think it seems to me that there would be a I mean, I think the evidence is clear in the parking area. Let's see. Okay, so that addresses that. And let me just look at some of the other issues raised. All right, that That's all the questions I have for you.
Thank you, sir.
All right, thank you. All right, so in looking through the code section, again, regarding how these hearings are handled, we usually have the rebuttal. It says in subsection, 255 subsection K, that in the interest of fairness and due process, the chair may choose to allow further responses from the applicant, staff, and/or parties in opposition, but the responses must be limited to issues addressed by the previous speaker. No new issues may be raised. That's essentially what I just did. And then in subsection L, there's a section for final argument. It says, following the completion of all rebuttal, the applicant will be permitted to provide a final argument. Any recognized party in opposition, don't need to worry about that. Staff shall be permitted final argument at the discretion of the chair. And final argument shall refer only to facts which were admitted into evidence. Argument that refers to facts not in evidence shall be disregarded by the board. So let's just say this for the record. All the materials in the packet are admitted as evidence. Okay? All the testimony that's been made sworn is evidence. So at this point, I don't know if the applicant has any final argument, but I'll allow final argument to the extent that it already hasn't been made. All right? Does the county staff have any final argument or presentation to make?
No, I don't think so. Thank you.
I have a question for staff.
Sure.
What about this traffic circulation point? Is it the county's position that this property is served by arterial or collector roads? The question was not answered by the applicant.
Right, it wasn't. Homosassa Trail accesses and then McClure and Hoskins from there. So that is an arterial collector roadway. The county is actually negotiating with the person to the west, that developer, to redo that entire intersection. It is a mess right now. We know
Which
that.
intersection are you talking about?
They're actually to the north of that. Can you go back to the aerial? Do you mind? That should show it. Didn't go all the way up. No, keep going. Aerial. The should go back a little more. Okay. All right. No. Yeah. I thought. How about yours? Trying to show the overview. Yeah, it's the same. I always cut it out. Okay. All right. So
Well, I see Homosassa Trail.
right. So Homosassa Trail, the roads go. It continues in that direction, like a triangle, and then access is what you're seeing there. McClure does a bend, and there's a Hoskins in there too. But it does. Homosassa Trail is an arterial collector. The code's not being waived. I know that was stated. The code says they're supposed to pave up to it. Our engineering staff did not feel that was necessary at this point. It's been maintained by not just them, but the shooting range and several other existing mines.
That was my next question about the paving.
Yeah, there's a lot of parties.
Well, the code says what it says.
Mm-hmm.
But the county has essentially, you're telling me that the county, to the extent that this may not strictly follow the code, the county's not concerned by it?
What I'm saying is at the time of permitting, our engineering staff will look at that and they can invoke this if they feel that's warranted.
I see.
It's not that it's being waived and we're doing this. There's not a waiver in these conditions in any way to say, and you don't ever have to pave it. They look at it as a case by case. In this one, they did not feel at this time to require it, but
Actually, you're right, Ms. Katu, because it says in the section, unless specified otherwise in the mining permit. So I think what you're saying is that, yes, these are all things being equal requirements, but the mining permit may say this part isn't allowed.
correct. And because I was starting to say we're redoing the intersection negotiations with the developer to the left, to the west. That particular residential subdivision needs to redo this intersection to get their property. So they're working on a development agreement on the border where this intersects Homosassa Trail, because there's mine trucks, there's a Circle K across the street, there's these guys coming in, it needs to be redone. So that intersection is going to change, we expect, in the future. It's just in negotiations, we're very early on. But because of that may automatically trigger a requirement to pave, but that would be engineering's call at that time.
Would that be the residential developer's responsibility, or?
Probably not, but I expect they're going to try to pull in some of these mining organizations to help them with some of the costs on this, yeah.
That's not something I can bank on.
No,
is-
no.
Okay. All right, then I appreciate the county's forbearance and letting me ask some more questions. I think that final argument has been made. Does the applicant have anything to say in response to the county's points? No, sir. Okay, all right, thank you. All right, then the next item on the procedure is that I shall publicly deliberate on the matter. No further presentations or testimony shall be permitted, and I will not ask any further questions of persons presenting testimony. I will discuss the evidence which was presented at the hearing and make findings on the matter. So, unless there's anything else from you all, I'm going to go into recess for 15 minutes or 12 minutes. I'll come back at 10:45 and issue my ruling. Thank you. I know we're a few minutes late. I'm just going to make some notes, and then I'll bring the hearing back into session, probably about 2 or 3 minutes. Yeah, you've got time.
I'm gonna set this hearing for that. Set the BCC hearing, because didn't want to pressure him into doing it today. I feel like last time he didn't do it today. By the way. Oh my goodness. Need more than chain.
All right, the time is 10:52, and I bring this hearing back to session. So I am ready to issue my ruling and recommendation. So here's what I'm going to do. I will make a finding that the proposal is consistent with the comprehensive plan pursuant to objectives 17.13 and policies 17.13.1 through 17.13.4, however, with the following conditions. First, the letter of financial responsibility is totally insufficient. It does not follow the code. So to the extent that this is a recommendation of the application, the condition is there must be full compliance with provision of necessary financial responsibility requirements in the code. Number two, There must be full compliance with the traffic circulation requirements in the code unless, pursuant to the code, the county finds good cause to accept those requirements in the permit. 3, there will be no waiver of the buffer requirements. And 4, there must be provision of a full reclamation plan explaining what will happen if it is not a landfill. I don't find sufficient evidence that I can accept that it will become a landfill. And the reason is, normally when you look at full reclamation, it has to do with environmentally sensitive areas. I don't have enough evidence to determine that that's really an issue here. There does seem to be adequate provision for gopher tortoises and the stuff that actually is environmentally sensitive under the code. It's not environmentally sensitive under any inventory that the county has provided. And so those will be my conditions with the recommendation that it is consistent with the comp plan. Any questions?
And also the county's recommended conditions. in the
Oh, and in addition to the county's conditions.
Get clarification, no waiver of buffer requirements. I think you might have meant setback.
Setback, well, it's the buffer, but yes, technically it's a setback requirement, correct.
Understand, thank you.
Any other questions?
Full reclamation plan,
Well, yeah, I mean, a reclamation, in other words, you commented that the reclamation plan was, that there could have been more. I
Correct.
mean, I think you were artful about it, but it's one page and it's 2 sentences, and it's not clear what the paper will become. It's not clear what the property will become. I heard at the hearing that there's a hope and an expectation it might become a landfill at some point. But I'm not even sure that's consistent with the one-page reclamation plan I have in here. So what I think the board would need to see is a reclamation plan that explains what will happen if it is not a landfill and how it will bring the property back to the way it was.
thank you. I was just looking for your word.
Not to be identical, by the way. It'll never be identical. I don't think the code requires that. I think that, people have to have extractive use of the property. This is already a property that is surrounded by extractive use, gun range, others. So it's very different from the last hearing.
Thank you. I was just trying to get your wording correctly.
Is there anything else? Okay. Time is 10:56. This hearing is adjourned.